All right, good morning, everyone. This meeting is called to order. Mr. Troman, is anyone signed up for public comment? Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
How are we today?
Very well, thank you.
Oh, good. Let's see, agenda item 3, no cases to reconsider.
Correct, no cases.
On tax liability cases under agenda item 4, I do think we have some tax cases to look at.
Good morning, Chairman. Good morning, Commissioners. For the record, Hugh Daniel, Special Program Appeals, and that's correct. There's one case on each docket. The case on docket 46 is case number TD-22-044-1222. Commissioner Esparza,
I agree with staff recommendations.
Commissioner Trevino,
I agree with staff recommendation.
and Chairman Daniel.
I agree with staff recommendation.
Thank you. This concludes consideration of tax liability cases on docket 46. The case on docket 47 is case number TD-23-019-0523. Commissioner Esparza,
I agree with staff recommendations.
Commissioner Trevino,
I agree with staff recommendation.
and Chairman Daniel.
I agree with staff recommendation.
Thank you. And this concludes consideration of cases on docket 47. The case on docket 48 is case number TD-23-014-0523. Commissioner Esparza,
I agree with staff recommendations.
Commissioner Trevino,
I agree with staff recommendation.
and Chairman Daniel.
I agree with staff recommendation.
Thank you. That concludes all the tax liability cases on these dockets.
All right. No fair housing cases on agenda item 5, no child labor cases on agenda item 6.
That's correct.
On agenda item 7, we have wage claim cases pulled on dockets 46 and 47.
That is correct. The docket 46, it's case number 23-050-266-8. Commissioner Esparza.
Give me one sec.
Yes, sir.
Thank you for that. The appeal tribunal decision is supportable. This is a difficult case of first impression, although it appears that both the claimant and the employer contributed to the problem caused by an apparent payroll diversion scam perpetrated by a third party. The claimant had the responsibility to monitor her own email account and guard against the third party using it. There's no indication that she attempted to share the fraudulent message with the bank and with legal authorities in an effort to identify the true sender's identity and other information. The employer acted in good faith and gave the claimant as much assistance as it could, but the claimant was the one with the access to whatever evidence of a hack that existed within her own account. Accordingly, we should affirm the appeal tribunal decision. No wages are owed to the claimant.
The WCAT decision is not supportable. The employer changed the claimant's direct deposit information without the claimant's authorization. There is credible and persuasive evidence that the employer received a phishing email that spoofed the claimant's email address and appeared to be from the claimant. The employer failed to verify with the claimant that she requested this change and changed the claimant's direct deposit account information without utilizing its direct deposit authorization form. The employer never delivered the wages to the claimant. Since the employer's failure to follow its policies regarding the direct deposit resulted in the payment going to a fraudulent account, the claimant is entitled to $4,200 in regular wages and $600 in vacation pay for a total of $4,800 in unpaid wages. Reverse the WCAT, $4,800 wages owed.
Reverse the WCAT, $4,800 in wages owed.
Short form consent.
Yes, sir. Moving on to docket 47, it's case number 22-051-651-2. Commissioner Esparza.
Thank you. The AT decision is partially supportable. I agree with the employer had good cause to miss the third hearing due to a family medical emergency. Concerning the issues of wages owed to the claimant, the employer has fully paid the claimant all of the wages he earned. The claimant signed a wage agreement indicating that his usual pay rate of 18 per hour would be reduced to $9 per hour for any week in which he failed to work at least 24 hours. The only firsthand testimony regarding the hours worked came from the employer, who stated the claimant worked a total of 22.5 hours during his last week. The testimony was not contradicted by the claimant, who did not appear at any of the 4 hearings held in the case. It is not a valid reason for finding against the employer on the hours worked issue that in an unrelated case, the investigator felt the employer was not credible. It is denial of due process to rule against the employer based on information outside of the record in this case that is under appeal, particularly since the employer has had no opportunity to explain those circumstances. Accepting the employer's testimony on hours worked as best evidence in this case, the claimant should have been paid $202.50, which is what the employer actually paid him. Concerning a bonus and a $100 deduction from the claimant's second to last paycheck, the claimant offered no testimony at any of the 4 hearings to support those parts of his claim. So the 4th AT hearing officer correctly denied to award the claimant those amounts. Accordingly, we should modify the AT decision from the 4th hearing. The employer had good cause to miss the 3rd hearing. No additional wages are owed to the claimant.
The WCAT 4 decision is correct. I agree that the employer established good cause for missing the WCAT 3 hearing. The employer provided conflicting and inconsistent testimony regarding the claimant's hours and pay rate. The claimant was terminated from his employment in the middle of the pay cycle, and the employer failed to provide him advance notice that his hourly pay rate for his last week of work would be reduced from $18 an hour to $9 an hour, according to the employer's hourly pay scale agreement. The claimant provided credible evidence that he worked 24 hours during his final week of employment, and that his pay rate could only be reduced to $9 an hour if he worked less than 24 hours that week. The best available evidence established that the claimant was entitled to $432 in wages for his final week of employment, in which he worked 24 hours at the pay rate of $18 an hour. However, the employer only paid the claimant $202.50 in wages and owes the claimant $229.50 in unpaid wages for his final week of employment. Affirm the WCAT 4. Employer established good cause for missing WCAT 3 hearing. $229.50 wages owed.
Employer established good cause for AT3, wage claim dismissed, no wages owed.
Short form dissent.
No wages are owed. That would be in the employer's favor
That's fine.
and against the claimant.
Short form dissent, ma'am.
Yes, sir. Those were the cases pulled for additional discussion on dockets 46, 47, and 48. You should have received the wage claim short form dissent list for dockets 46, 47, and 48.
I move we accept staff recommendations on the remaining wage claim cases on dockets 46, 47, and 48.
Chairman, I second the motion, except for those cases in which I am dissenting as reflected on wage claim short form dissent list for docket 46, 47, and 48.
I concur with the chairman's motion, except for the case in which I'm dissenting, as reflected in wage claim short form dissent for dockets 46, 47, 48.
Motion passes with the exceptions noted.
Thank you.
Thank you. Let's move to agenda item 8, consideration of unemployment insurance cases. Proceed when you're ready, please.
Starting with docket 46.
The following 7 cases will be called together and voted on as one. Case number 3405355, 3405359, 3405367, 3405426, 3405429, 3405431, 3405459. Commissioner Esparza.
The AT decisions in these 7 identical companion cases are not supportable. The employer's appeal were only 1 day late. The employer's testimonies and its appeals established that during the appeal period, the company was in touch with TWC to clear up its access problems with the EBS system. While the employer still had time to file an appeal by fax or mail or delivery to a TWC office, TWC staff were not so advising the employer. It does not appear that at any point a TWC employee clarified for the employer that it could and should appeal by an alternate method, just in case the EWS access issues took too long to resolve. The lack of proper information from TWC staff regarding the appeal process amounted to misinformation under Commission Rule 32, and so the late appeal should be excused. Accordingly, we should hold the employer's appeals in these 7 companion cases timely and have the cases resubmitted on the merits of the chargeback issue in each case.
The AT decision is correct. The employer received the charge liability decision at its address of record, but failed to file a timely appeal because their employees were working from home and not regularly checking the employer's mail. There is no good cause exception to the timeliness rule, and the employer has not alleged that they received any misinformation from the commission. The employer was fully aware of the claim, as they had responded to the notice of chargeback review, and they were responsible for responding to the mail sent to their address of record in a timely manner. Affirm the AT, late employer appeal, chargeback.
Untimely employer appeal, chargeback.
Short form dissent.
Yes, sir.
Case number 3101222, Commissioner Esparza.
The appeal tribunal decision should be affirmed. The claimant contends he should be allowed to backdate his claim because he thought the employer was going to provide him with more work. The situation amounts to the claimant not filing his claim when he first had the opportunity to do so and does not constitute adequate cause for backdating his claim. Moreover, the claimant was never erroneously misled or discouraged by a TWC representative to not file his claim when he became separated from work. Since the claimant of his own accord decided to wait for the employer to offer him more work instead of filing his claim, there is no hardship or injustice for the commission to prevent. We should therefore affirm the AT decision, deny the claimant's request to backdate the claim.
The AT decision is not supportable. The claimant's employer promised the claimant further work, but that work never materialized. The claimant has demonstrated adequate cause for backdating the claimant's additional claim dated November 28th of 2021 to November 14th of 2021. Reverse the AT, backdate additional claim dated 11/28 of 21 to 11/14 of 21.
Backdate the AC to November 14th, 2021.
Short form dissent.
Yes, sir.
Case number 3228722, Commissioner Esparza.
The appeal tribunal decision is not supportable. Due to mail problems associated with pandemic, the employer did not receive notice of the claimant's claim until almost a year after it had been mailed by TWC. Once the employer had notice of the claim, the company was given erroneous information by the TWC department regarding how it could protest the claim with a bulk response. A month and a half later, the employer learned that what it was originally told was wrong and that it needed to protest each claim individually. Based upon what it heard from TWC, the employer was under the impression that it should have received a different kind of notice. Due to the lack of clear and consistent guidance from TWC concerning the notice and how to respond, the employer's ultimate response was filed on December 17th, 2021 and should be considered timely. We should reverse the AT decision and hold the protest timely. However, since the claimant's benefit rights are at stake and the claimant was not at the hearing on November 29th, 2022, we need to remand the case to the appeal tribunal for a hearing on the work separation and chargeback issues.
The AT decision is correct. The commission mailed the employers a notice of application for unemployment benefits to the correct address on record. Here, the employer was clearly aware of the claimant's filing, that they failed to respond before the commission's deadline. The employer failed to file a timely response, and they did not deny receiving the notice. Affirm the AT, late employer protest.
Timely protest, resubmit.
We have a majority vote that the protest is timely, but different votes on what to do with the underlying merits. Commissioner Esparza voted to remand to the AT, and Mr. Chairman, you voted to resubmit.
I agree with the chairman.
Thank you. We will resubmit this case.
Case number 329-3331, Commissioner Trevino.
The AT decision is not supportable. The claimant was approved for PUA benefits and filed claims through the benefit week ending 3/6 of 21. It was not until several months later, on 10/19 of 21, that the commission sent the claimant a notice to provide proof of employment. The claimant was not checking his electronic inbox on a regular basis at that time, which was reasonable considering how long it had been since he requested benefits. And no notice to check his electronic inbox was sent to his personal email. However, once the claimant became aware of the request for information on 11/18 of 21, he uploaded his proof of employment that same day. Reverse the AT, PUA eligible beginning 12/27 of 20, no overpayment.
The appeal tribunal decision is supportable. The claimant had elected to receive TWC claim related correspondence electronically, which carried the obligation to check his electronic inbox on the unemployment benefit system online on a regular basis. He did not do so, leading to his late response to a requirement that he furnish employment related documentation to support his claim for pandemic unemployment assistance benefits after December 27th, 2020. Submitting such documentation was a requirement under the federal law that extended the PUA benefits program past the end of 2020. His ineligibility for the PUA benefits that he received in 2021 created an overpayment. Accordingly, we should affirm the appeal tribunal decision. The claimant was ineligible for PUA benefits beginning December 27th, 2020, overpayment of $2,070.
PUA eligible, no overpayment.
Short form dissent.
Yes, sir. Thank you.
Case number 329-3341, Commissioner Trevino.
The AT decision is not supportable. The claimant was approved for PUA benefits and filed claims through the benefit weeks ending 3/6/21. It was not until several months later, on 10/19 of 21, that the commission sent the complainant a notice to provide proof of employment. The claimant was not checking his electronic inbox on a regular basis at the time, which was reasonable for how long it took since he requested benefits. And no notice to check his electronic inbox was sent to his personal email. However, once the claimant became aware of the request for information on 11/18 of 21, he uploaded the proof of employment that same day. The commission's delay in requesting the information contributed to the claimant providing the information late, and the waiver should be granted. Vote for or approve waiver. If the vote for case 329-3331, I'm going to say comment the PUA eligible overpayment determinations were reversed in case and void. Well, excuse me, just 1 minute. Ma'am, I'm just going to say to void the waiver.
Yes, sir. Your vote is to void the waiver.
Correct. Thank you.
Void the waiver.
Void the waiver, sir.
Second.
Yes, sir.
Void the waiver determination.
It's unanimous. Thank you.
Case number 351-2743, Commissioner Trevino.
The AT decision is not supportable. The claimant's separation was due to a medically verifiable illness. The claimant was unable to perform some job for job duties due to a lingering medical issue. The claimant's physician advised her that she should work from home until she fully recovered. The claimant requested an accommodation for her medical concerns with her manager, and HR and the employer failed to adequately address her requests regarding her health concerns. Reverse the AT, no voluntary leaving, no chargeback, MPI.
Did he say no chargeback? I'm sorry.
His vote was to protect the employer, pay the claimant and protect the employer.
We should affirm the appeal tribunal decision. The claimant provided several reasons for quitting. However, the preponderance of the credible evidence established that the claimant quit because she did not want to work with her new supervisor. Since the claimant quit effective immediately and without providing the employer an opportunity to address her concerns, she quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
Voluntary leaving, no chargeback.
That's short form dissent now.
Yes, sir. Short form dissent on chargeback. Sorry, on separation. It's your choice to just do a general dissent or to segregate your dissent to the separation.
Short form dissent.
Full dissent. Thank
Yes.
you.
Excuse me, case number 3517904, Commissioner Esparza.
The commission should rehear this case. Although the employer was unable to provide evidence to establish chain of custody of the drug testing sample at the AT hearing, in their appeal to the commission, the employer stated that the evidence was unavailable at the time of the AT hearing, but is now available for review. Since the employer's additional evidence is critical to ascertain whether the claimant's positive drug test constituted misconduct, we should rehear this case to admit the employer's additional information related to the employer's chain of custody. Rehear.
The AT decision is correct. The claimant provided credible firsthand testimony denying that he used a controlled substance in violation of the employer's policy. The employer failed to submit documentation establishing that the chain of custody of the claimant's random drug test sample was maintained. Therefore, the employer failed to satisfy one of the 5 required elements required to be present as evidence and did not satisfy its burden of proving misconduct. Affirm the AT, no misconduct, tax governmental employer.
Rehear.
We will rehear the case.
Case number 3524711, Commissioner Esparza.
We should modify the appeal tribunal decision. First, the employer should be designated as a party of interest. Regarding the job separation, the claimant knew he was required to service his customers' beer lines every 2 weeks. Customer complained because the claimant had not carried out this duties as required. Claimant admitted that he visited the customer but did not service the bar because he was only there for a few minutes. By failing to carry out his assigned duties, the claimant mismanaged his position of employment. We should modify the AT decision, misconduct. The employer is a party of interest.
The AT decision is not correct. The employer failed to meet their burden of proof in presenting any evidence providing that the claimant was discharged for work connected with misconduct. The claimant's sworn firsthand testimony denying any allegations of misconduct should be given greater weight than the employer's secondhand hearsay evidence. I won't contest the fact that the employer is a party of interest. Reverse the AT, no misconduct, employer is PI.
No misconduct, employer is a party of interest, and then I'd like to request a memo to investigate possible unreported earnings.
Memo for unreported earnings? Yes, sir. And the claimant is prevailing in this case. So you can dissent if you wish.
Dissent on the no misconduct.
Yes, sir.
Case number 3526125, Commissioner Esparza.
The appeal tribunal decision should be reversed. The claimant was terminated after creating disturbance at the workplace that could not be ignored. As the only party to attend the hearing, the employer testified that the claimant repeatedly tapped her foot in a manner that created noises against her computer or the wall all day. Claimant was asked repeatedly to stop, but did not. The employer provided multiple witnesses' statements in the filed documents for employees who asked the claimant to stop her distracting behavior to no avail. Because the claimant was asked multiple times by multiple employees to stop a behavior that was created a disturbance at the workplace, she knew or should have known she could be terminated for her actions. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response. In the alternate, since the claimant provided fact-finding statement that the disturbance she created could be tied back to a medical issue, I could also agree with the vote of no misconduct and no chargeback due to separation being the result of the claimant's medically verifiable illness.
The AT decision is correct. The claimant was discharged from her job after continuously tapping her foot after being asked to stop by her coworkers. The claimant was battling a health condition which caused her to shake her leg while working. The claimant never received any warnings about her conduct. Thus, the employer failed to establish that the claimant's actions violated any company policy or that her behavior was so egregious that it rose to the level of misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
No misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 3538623, Commissioner Esparza.
Commission should grant a rehearing in this case. The employer terminated the claimant for alleged theft. The employer testified that video footage depicts the claimant putting money on her body instead of the money in the money bag multiple times. Since this video evidence would be highly relevant in determining what occurred during the final incident, we should rehear this case for the employer's video evidence.
The AT decision is correct. The claimant was discharged for mishandling money received by the employer, which resulted in missing cash. The claimant denied misappropriating any money from the company, and she has not been charged or convicted of any wrongdoing. Additionally, the claimant testified that everyone in the employer's office handled the money. The employer failed to provide sufficient evidence to overcome the claimant's sworn denial of the allegations and failed to establish that the claimant's action constituted misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Rehear.
We will rehear the case.
Case number 3553880, Commissioner Trevino.
The AT decision is not supportable. I agree that the validity of claim issue should be severed. Regarding the separation, the employer provided no firsthand testimony or documentary evidence regarding any specific incidents of misconduct. The claimant admitted that while working in a kitchen, when he was behind an employee carrying a sharp implement or hot food, he would touch the employee to let them know that he was there for safety purposes and to ensure that they did not back up into him. There is no evidence that the employees ever expressed to the claimant that this made them feel uncomfortable or that it was done in an inappropriate manner. The claimant's acknowledgement of these actions without any evidence that the claimant knew or should have known that his actions were inappropriate does not constitute misconduct connected with the work. Modify the AT, no misconduct, chargeback, sever validity of claim, void adequate response.
We should modify the appeal tribunal decision by touching employees without their consent. The claimant violated the employer's zero tolerance harassment policy. Accordingly, he was discharged for misconduct connected with the work. We should modify the AT decision, misconduct, no chargeback, several of validity of the claim, and adequate response issues.
No misconduct, chargeback, void adequate response, sever validity of claim.
Short form dissent.
Yes, sir. That was the last pulled unemployment insurance case on docket 46. You should have received the UI short form dissent list for docket 46.
I move we accept staff recommendations on the remaining UI cases on docket 46.
I second the motion except for those cases on which I am dissenting as reflected in the UI short form dissent list for docket 46.
I concur with the chairman's motion, except for the cases in which I'm dissenting as reflected in UI short form dissent list for docket 46.
Motion passes with the exceptions noted.
Thank you. Moving to docket 47.
Case number 3405372, Commissioner Esparza.
The AT decision is not supportable. The employer's appeal was only 1 day late. The employer's testimony and its appeal established that during the appeal period, the company was in touch with TWC to clear up its access problems with the EBS system. While the employer still had time to file an appeal by fax or mail or delivery to the TWC office, TWC staff were not so advising of the employer. We're not so advising the employer. It does not appear that at any point a TWC employee clarified for the employer that it could and should appeal by an alternate method, just in case the EBS access took too long to resolve. The lack of proper information from TWC staff regarding the appeal process amounted to misinformation under Commission Rule 32, and so the late appeal should be excused. Accordingly, we should hold the employer's appeal timely and have the case resubmitted on the merits of the chargeback issue.
The AT decision is correct. The employer received the charge liability decision at its address of record, but failed to file a timely appeal because their employees were working from home and not regularly checking their employer's mail. There is no good cause exception for the timeliness rule, and the employer has not alleged that they received any misinformation from the commission. The employer was fully aware of the claim as they had responded to the notice of chargeback review, and they were responsible for responding to the mail sent to their address of record in a timely manner. Affirm the AT late employer appeal chargeback.
Rehear to better develop the record as to timeliness.
Rehear on timeliness.
I agree with Chairman on that.
Thank you. We will rehear the case.
Case number 3409184, Commissioner Trevino.
This case should be reset for an additional rehearing. The claimant's copy of the hearing notice and the AT decision were returned to the commission as undeliverable, and a rehearing was scheduled for 10/31/23. Though staff indicates that the rehearing notice was sent to the parties, the mailing was not documented appropriately in the commission records. Additionally, though prior documents mailed to the claimant were returned to the commission as undeliverable, the claimant's address was not verified with the claimant. Since our records do not show that the rehearing notice was sent to the parties, an additional hearing should be scheduled to provide notice to the rehearing to the parties and ensure that the commission records reflect that the claimant's due process rights have been met. Rehear.
The claimant's appeal to the commission should be dismissed as late. Although the AT decision was sent to the claimant's correct address of record, he filed his appeal after the applicable appeal deadline. Since there are no good cause exceptions to the timeliness rules, we should dismiss the claimant's appeal to the commission as late and leave the underlying AT decision in full force and effect.
Late commission appeal, the AT decision remains in full force and effect.
Short form dissent, ma'am.
Yes, sir.
Case number 3423071, Commissioner Trevino.
This case should be reset for an additional rehearing. The claimant made a Guzman allegation in her appeal to the commission, and a rehearing was scheduled for 11/7/23. Though staff indicates that the rehearing notice was sent to the parties, the mailing was not documented appropriately in the commission records. Since our own records do not show that a rehearing notice was sent to the parties, an additional rehearing should be scheduled to provide notice of a rehearing to the parties and ensure that the commission records reflect that the claimant's due process rights have been met. Rehear.
The claimant's appeal to the commission should be dismissed as late. The claimant's appeal was filed after a deadline. Excuse me. We're at 3423071, correct?
Yes, sir.
Okay, thank you. Claimant's appeal to the commission should be dismissed as late. The claimant's appeal was filed well after the deadline to file a timely appeal. Despite a hearing being scheduled to examine the claimant's allegation of non-receipt, claimant did not appear for the hearing. Since there are no good exceptions to the timeliness rules, we should dismiss the claimant's appeal to the commission as late, leave the underlying AT decision in full force and effect.
Late commission appeal, the AT decision remains in full force and effect.
Short form dissent, ma'am.
Yes, sir.
Case number 3436819, Commissioner Trevino.
The AT decision should be modified. I agree that the claimant had good cause for her failure to appear at the prior hearing, as she did not receive the hearing notice. However, regarding the job separation, the evidence established that the claimant worked for the employer on an as-needed basis. The claimant's work hours were variable depending on the needs of the employer. So she didn't know at the end of each shift when or if she would be scheduled for additional work. Therefore, under commission precedent, the claimant was laid off due to lack of work at the end of each scheduled shift. Modify the AT, claimant had good cause for AT1, no misconduct, chargeback, void adequate response.
The appeal tribunal decision should be modified. I do not contest the good cause issue. As for the job separation, the claimant quit her job because of dissatisfaction at the workplace. Specifically, the claimant quit because her request to work remotely was ultimately denied due to HIPAA concerns, and she felt aggrieved by the employer's feedback about her typing skills. However, per the employer's testimony, there is no record of the claimant talking to her supervisor or contacting HR about being dissatisfied. Although the claimant was a PRN employee, the employer's testimony reflects that her schedule was typically routine and that continued work would have been available. As such, it is appropriate to conclude that the claimant initiated the job separation by resigning. Accordingly, since the claimant failed to allow the employers an adequate opportunity to remedy her concerns, she quit without work-connected good cause. We should therefore modify the AT decision. The claimant had good cause for her non-appearance, voluntary leaving, no chargeback, sever adequate employer response.
Claimant established good cause for AT1, voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir.
Case number 3466363, Commissioner Esparza.
This case is not yet ready for a decision on the merits of the reimbursement liability issue. The employer's appeal to the AT should be considered timely because of the wage verification notice was sent during the height of the pandemic technical difficulties period, and the employer gave credible and consistent testimony that did not receive the original notice. Regarding the merits of the reimbursement liability issue, the employer's testimony and other evidence indicate the possibility that the claimant was one of many school district employees who were employed and paid their regular wages during the period of school closures at the time of the pandemic. However, since the employer did not report wages during 2020, the tax department needs to look into that issue. Since it is also possible that the claimant may have intentionally failed to report the earnings that the employer's witness testified were paid, the issue of unreported earnings should also be investigated. Accordingly, we should have the case resubmitted following an investigation by the tax department and by the FDCM division.
The AT decision should be modified. The employer's appeal should be deemed timely. Regarding the reimbursement issue, the claimant filed an initial claim establishing a benefit year beginning March 15th of 2020 after separating from a different employer. There is no separation from the named employer. A reimbursing employer's account may only be protected from billing when the claimant was discharged for misconduct connected with the work or when the claimant voluntarily leaves without good cause connected with the work. In this case, since there is no separation from the named employer, billing the reimbursing employer's account is appropriate. Modify the AT, timely employer appeal, bill the reimbursing employer.
Timely employer appeal, reimbursing employer not billed, memo to investigate possible unreported earnings.
1 second. Agree with the chairman.
Thank you, sir.
Yes, ma'am.
And we will send that memo.
Short form dissent.
Yes, sir.
Case number 3475442, Commissioner Esparza.
Thank you. We should reverse the appeal tribunal decision. Although the employer maintained a policy which prohibited harassment, the claimant was terminated when multiple coworkers brought forth allegations of improper behavior by the claimant. While the claimant alleged no wrongdoing, The employer provided multiple firsthand witness statements which corroborated the claimant's bad acts. As the manager, the claimant should have been aware of the employer's policy. Since the claimant violated the policy on multiple occasions with various coworkers, the claimant's actions were mismanagement of his position of employment and misconduct connected with the work. As such, we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision is correct. The employer discharged the claimant based on allegations that he engaged in inappropriate conduct or behavior. The claimant provided consistent and credible firsthand testimony denying the employer's allegations. The employer failed to provide firsthand testimony regarding the claimant's conduct and relied on hearsay testimony and unsworn statements. Therefore, the employer failed to establish that the claimant engaged in the alleged misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
No misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 3482556, Commissioner Esparza.
The appeal tribunal decision should be modified. I do not contest the validity of the claim issue. As for the job separation, the claimant was fired for receiving kickbacks. Since the claimant did not appear for the hearing, he did not deny the employer's testimony under oath or was subject to cross-examination. Moreover, 2 employer witnesses testified that the claimant was confused with the issue of kickbacks. The claimant did not deny the allegations. As such, the claimant mismanaged his position of employment, was discharged for misconduct connected with the work. We should therefore modify the AT decision, valid claim, misconduct, no chargeback, adequate employer response.
The AT decision is supportable. The claimant filed a valid claim. The employer has presented vague allegations that the claimant received improper payments from the employer's clients. The employer failed to provide specific dates or amounts of the alleged improper payments. The claimant denied that the employer's allegations in his fact-finding statements provided to the commission. Since the employer's allegations lack specific proof, the employer has failed to establish that the claimant committed misconduct connected with the work. Affirm the AT, valid claim, no misconduct, chargeback.
Rehear to better develop the record and allow the employer to present its additional evidence.
I agree with the chair.
Sorry, sir.
I agree with the chair.
We will rehear the case.
Case number 3510926, Commissioner Trevino.
The AT decision is not supportable. The claimant has provided credible and persuasive testimony in which he denied the allegations of misconduct. The claimant only acted at the direction of management. The employer has the burden to prove misconduct, and they have merely offered secondhand hearsay testimony and evidence to support their allegations. The employer failed to present sufficient evidence to overcome the claimant's sworn testimony and to prove that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The weight of the credible evidence establishes that the claimant did not follow specific directions that were left for him by a supervisor, which resulted in 3 incidences of unprofessional behavior. The employer's evidence should be given greater weight since the claimant provided inconsistent testimony. Claimant first denied that he received any directions regarding vehicles by the employer, but then stated that he was directed to take a vehicle in for service on its suspension. As such, the claimant's failure to follow their directions constituted misconduct connected with work. We should therefore affirm the AT decision, misconduct, no chargeback.
No misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 3529004, Commissioner Esparza.
We should modify the AT decision. The employer suspended the claimant based on an investigation of abuse and neglect by Adult Protective Services. I agree that the employer has not met its burden of providing that the claimant was discharged for misconduct connected with the work. However, the employer testified that it was required by law to suspend the claimant pending in the investigation. Since the separation was required by law, the claimant should be qualified for benefits and the employer's account should be protected from charge. Accordingly, we should modify the AT decision, no misconduct, no chargeback, separation required by operation of law.
The AT decision is correct. The claimant provided credible firsthand testimony denying the employer's allegation that she either neglected her job duties or caused any harm to the employer's patients. The employer provided only secondhand evidence to support these allegations. Therefore, the employer failed to meet its burden, proving that the claimant was discharged for misconduct. Affirm the AT, no misconduct, chargeback. In the alternative, we would agree with the finding that this separation was the result of operation of law. If the employer could no longer employ the claimant pending the completion of the investigation, modify the AT, no misconduct, no chargeback, operation of law.
No misconduct, no chargeback, urgent and compelling.
We have unanimous decision of paying the claimant and protecting the employer's account. We do have two votes that it's operation of law. And your vote only is for a different rationale, sir.
Yeah.
Do you wish to go ahead with this or dissent?
That's my vote right there. I'll dissent on the reason.
Yes, sir.
I
That's,
can't determine which law they're operating under, so it's urgent and compelling.
yes, sir. Urgent and compelling with your dissent. The majority vote is operation of law.
Thank you.
Case number 3533623, Commissioner Trevino.
The AT decision is not correct. The claimant provided her employer advance notice of her request to take time off, and her supervisor ignored her request for leave. The claimant properly complied with the employer's policy regarding requesting approval in advance for future scheduled absences. The claimant had no reason to believe her absence would lead to termination, and she had not received any prior warnings about her attendance. Therefore, the claimant's actions did not rise to the level of misconduct. Reverse the AT, no misconduct.
We should affirm the appeal tribunal decision. The claimant was absent for 2 days without permission from her supervisor. Thus, the claimant mismanaged her position of employment. Affirm the AT decision misconduct.
Misconduct.
Short form dissent, ma'am.
Yes, sir.
Case number 3533732, Commissioner Esparza.
We should affirm the appeal tribunal decision. The employer's policy specified that 2 traffic occurrences in a 3-year period could lead to termination of employment. The claimant was terminated when, after receiving prior warnings for falling asleep behind the wheel. The claimant again caused a traffic incident by sleeping while driving. Although the claimant denied his actions, the employer's dash cam footage showed that the claimant was in fact asleep and that his negligence directly resulted in a traffic occurrence. Since the claimant was aware of the employer's policy and because the claimant was warned for his prior traffic incidents, his repeated violation of employer's rule was mismanaged of his position of employment. As such, we should affirm the AT decision misconduct, no chargeback.
The AT decision should be modified. Though the claimant violated the employer's policy by falling asleep while operating the employer's vehicle, the claimant's actions were not intentional, as the claimant indicated in his appeal that his firing led him to understand that he had a medical issue for which he sought treatment. This medical issue caused the claimant to fall asleep without warning. Since the claimant's actions were caused by his illness, his actions did not constitute misconduct connected with the work. Modify the AT, no misconduct, no chargeback, MVI. If my fellow commissioners don't agree with the claimant should not be disqualified because his actions were caused by illness, I would agree to rehear this case to allow the claimant to submit medical documentation related to his condition.
Rehear.
We will rehear the case.
Case number 3537993, Commissioner Esparza.
The AT decision should be modified. The claimant was fired for cleaning after being told not to do so. The parties disagree as to why the claimant responded to the employer's instruction to stop cleaning. What is not in dispute is that the claimant did not comply with the employer's instructions. The claimant had received a prior warning which notified her that any other incidents with any other employees would result in discharge since the employer had spoken to the claimant about her disruptive behavior in the past. As such, the claimant knew or should have known her job was in jeopardy and should have simply followed the employer's instructions to stop cleaning rather than ask other employees if she was bothering anybody. Accordingly, the claimant mismanaged her position of employment, which constituted work-connected misconduct. We should therefore modify the AT decision, misconduct, no chargeback, sever adequate employer response, and we should send a memo to UIA and OS to investigate any possible unreported earnings by the claimant.
The AT decision is not supportable. The employer discharged the claimant for a disagreement with another employee in front of her coworkers. The claimant provided credible testimony that she did not yell or raise her voice towards her coworkers. The employer has failed to meet its burden of proving that the claimant engaged in any misconduct that would constitute misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response.
Misconduct, no chargeback, sever adequate response.
A short form dissent, ma'am.
Yes, sir.
Case number 3538854, Commissioner Trevino.
The AT decision is not supportable. The employer ordered a chair for a claimant to use while working. Other employees began taking the claimant's chair while he was not using it. The claimant began temporarily placing the chair in his van to prevent his coworkers from taking the chair. And he believed that he had permission from HR to take the chair home when he was working at home on his laptop. When the employer asked the claimant to bring the chair back to the office, he immediately did so. It was never the claimant's intention to steal the chair. The employer failed to present any other allegations of misconduct and has failed to present sufficient evidence to prove that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
We should affirm the AT decision. Claimant took employer property off the premises and hid it in his van for an extended period of time. The claimant assumed that he was authorized to do so, but did not confirm with the employer. By removing company property off the premise without authorization, the claimant mismanaged his position of employment. From the AT decision, misconduct, no chargeback.
Misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3633385, Commissioner Trevino.
The AT decision is not supportable. The claimant submitted updated medical documentation, properly updating his employer with details about his health situation and the reason for his absences. The claimant submitted a valid leave request due to a medical condition he was experiencing, which made it difficult for him to perform his daily job tasks. The claimant requested for a 30-day leave of absence for health reasons was a reasonable and valid request and is not considered misconduct. Reverse the AT, no misconduct, bill reimbursing employer.
We should affirm the appeal tribunal decision. The claimant was discharged for attendance issues after prior warnings. Final incident seems to be the claimant taking an extended leave of absence without prior approval from the employer. The claimant's fact-finding statement is established that his leave request was not based on the advice of his doctor. Because the claimant took personal leave without authorization from the employer, he mismanaged his position of employment. We should affirm the AT decision, misconduct, reimbursing employer not billed.
Misconduct, reimbursing employer not billed.
Short form dissent.
Yes, sir. And that was the last case pulled for additional discussion on docket 47. You should have received the UI short form dissent list for docket 47.
I move we accept staff recommendations on the remaining UI cases on docket 47.
I second the chairman's motion, except for those cases in which I am dissenting as reflected in the UI short form dissent list for docket 47.
I concur with the chairman, except for the cases in which I'm dissenting as reflected in UI short form dissent list of docket 47.
Motion passes with the exceptions, Garrett.
Thank you. Moving to docket 48.
Case number 3003435, Commissioner Esparza.
We should affirm the appeal tribunal decision. Claimant quit his job to attend school full-time. This is confirmed and corroborated by the letter of resignation he submitted to the employer and by the two fact-finding statements he provided TWC shortly after his separation. The claimant later changed his story and alleged that he quit due to actions from his supervisor which were not resolved by the employer. This is not persuasive in light of his previous statements. Thus, because the preponderance of the credible evidence established the claimant quit for personal reason, he quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
The AT decision is not supportable. The claimant provided firsthand testimony that he had been assaulted by his supervisor and quit after the employer failed to adequately address the assault. The employer only provided hearsay testimony and merely speculated that the claimant had not been assaulted. The claimant's complaints about the work environment were legitimate, and the employer failed to properly address those complaints. Therefore, the claimant had good cause connected with the work to quit. Reverse the AT, no voluntary leaving, chargeback.
Voluntary leaving, no chargeback.
Short form dissent now.
Yes, sir.
Case number 325-3378, Commissioner Trevino.
The AT decision should be modified. The claimant's commission appeal should be deemed timely because she did not receive a copy of the AT2 decision. And commission records indicate that the decision was returned to the commission as undeliverable. The claimant established good cause for missing AT1 hearing because her minor child was ill and no one else could care for her child. Regarding the PUA eligibility issue, the claimant's services of a babysitter were no longer needed by her client as a direct result of the pandemic. The claimant provided a statement to the commission from her client indicating that the work ended due to the pandemic. Modify the AT, timely CA appeal. Claimant established good cause for missing AT1, PUA eligible beginning 3/7/21.
We should hold the commission appeal timely and affirm the AT decision. I agree that the claimant's appeal to the commission was timely due to her non-receipt of the original copy sent to her. I also agree that the claimant had good cause to miss the first hearing. Concerning the merits of appeal, the claimant offered no credible evidence that she met the program requirements for pandemic unemployment assistance benefits in 2021. Her testimony at the hearing was contradictory and differed substantially from her earlier claim statements and the available documentary evidence. In addition, there were strong indications that the claimant's contradictory statements were due, at least in part, to some undisclosed coaching that the claimant was receiving from an unknown third party who was with the claimant while she was speaking. Accordingly, we should hold the commission appeal timely and affirm the AT decision. The claimant filed a timely appeal to the commission. The claimant had good cause to miss the first hearing, and the claimant was ineligible for PUA benefits beginning March 7, 2021.
Timely commission appeal, claim established good cause for AT1, PUA not eligible beginning March 7th, 2021.
Short form dissent now.
Yes, sir.
Case number 3311003, Chairman Daniel.
The record was not fully developed on the issue of the claimant's good cause for missing AT1, which is a material issue in this case. Grant the motion for rehearing.
The claimant's motion for rehearing should be granted. The claimant has presented evidence that he was wrongfully terminated. I'll agree with the chair. Motion for rehearing.
The claimant's motion for hearing should be denied. He offered no new evidence on the relevant issue, which was whether he had good cause to miss the first appeal hearing. And in his request to reopen the first hearing, he stated that he missed the hearing because he had heard that the hearing would be recorded and used against him politically. The relevance of that reason for missing the hearing is questionable since the same risk would have existed in his testimony at the third hearing, and it did not prevent him from testifying then. Since the claimant had offered no new evidence that would change the outcome of the case, he has not met the three-part test for granting a rehearing. Accordingly, we should deny the motion for rehearing. No new evidence.
Majority vote is to grant the motion for rehearing. The case will be resubmitted on a future docket.
Case number 3340536, Commissioner Trevino.
The claimant's motion for rehearing should be granted. The claimant has presented new evidence that he was unable to participate in the commission-directed rehearing because he was out of the country at the time of the hearing. Therefore, the claimant had the opportunity to hear the testimony and evidence offered by the employer at the rehearing, cross-examine the employer's additional witnesses, or offer rebuttal testimony. The claimant should be given a chance to establish that he had good cause for failing to appear at the rehearing and present additional evidence. Grant claimant's motion for rehearing.
The claimant's motion for rehearing should be denied. Specifically, the claimant does not provide a compelling reason for not providing his new evidence earlier, nor does he provide an explanation as to how his new evidence would change the outcome of the case. Since the claimant has not met the requirement criteria for successful motion for hearing, it should be denied. Deny the claimant's motion for rehearing.
Grant the motion for rehearing.
Motion for rehearing has been granted. We will resubmit the case.
Case number 33991122, Commissioner Esparza.
The AT decision is not supportable. The employer has a very busy eye care clinic and missed the first hearing in favor of taking care of his patients who had appointments. We give deference to the claimants who are busy with new jobs, and we should show the same understanding with employers who are trying to keep up with the demands of their small business. Accordingly, we should find that the employer had good cause to miss the first hearing and have the case resubmitted on the issues of timeliness of protest and chargeback. In the alternative, since the written record contains consistent testimony regarding non-receipt of the chargeback notice by the employer and the deadline for responding within the period in 2020 during which TWC postal and community systems were overwhelmed by the pandemic, I would also support finding that the employer had good cause to miss the first hearing and that the employer filed a timely protest to the notice of maximum potential chargeback, and that the case should be resubmitted on the chargeback issue.
The AT decision is correct. The employer received notice of hearing for AT1 hearing, but did not appear for the hearing because the employer did not believe that their presence was necessary. There is a circumstance entirely within the employer's control, and the employer has failed to establish that they had good cause for missing the hearing. Regarding the timeliness, the employer's protest to the notice of maximum potential chargeback, the AT1 decision, which affirmed the determination holding that the employer's response to the notice of maximum potential chargeback should be dismissed as late, is supportable. The notice of maximum potential chargeback was sent to the employer on February 20th of 2020, prior to the beginning of COVID-19 pandemic mailing issues, and the employer did not file a response over 2 years. Affirmed the AT, employer did not have good cause for AT1. Late response to the notice of maximum potential chargeback. Employer's account remains charged.
Employer did not establish good cause for AT1. Untimely response to the NMPC chargeback.
Short form dissent.
Yes, sir.
Case number 3512933, Commissioner Esparza.
The AT decision should be reversed. The claimant was fired for sending an unprofessional text message to 2 members of management. While the claimant may have been experiencing some dissatisfaction at the workplace, the claimant knew or should have known that sending a text message with the type of language that the claimant used would result in termination. The employer also testified that the claimant had received prior warnings for his insubordination. As such, the claimant's action constituted work-connected misconduct. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision is correct. The claimant was terminated from his position for expressing his concerns with management about his assigned hours and working conditions. Employees are expected to bring concerns regarding their working conditions to the employer's attention, and the claimant expressed frustration with the working conditions without specific evidence of prior warnings is not sufficient to establish misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
No misconduct chargeback.
Short form dissent.
Yes, sir.
Case number 3531354, Commissioner Esparza.
We should grant a rehearing in this case. The employer informed the hearing officer that it wanted its protest documents considered as evidence in the hearing. Although these documents had been received by TWC they had not been included in the hearing packet. Because the AT failed to admit or review these documents prior to making its decision, the employer had requested that the documents be considered. We should grant a rehearing for admission and review of these documents.
The AT decision is correct. The claimant was terminated for statements she made in an email sent to another employee discussing medical symptoms related to COVID-19. The claimant was apprehensive about returning to work for her next shift after this communication with her coworker, and she was fearful of contracting COVID-19. The employer does not have a policy prohibiting employees from discussing illnesses with each other if the coworkers consent. The employer failed to establish that the claimant mismanaged her position of employment and that the claimant's action did not rise to the level of misconduct connected with the work. Affirm the AT, valid claim, no misconduct, chargeback.
Valid claim, misconduct, no chargeback, adequate employer response.
Excuse me, did he say no chargeback?
Mhm.
Mr. Chairman, the vote I have for you is valid claim, misconduct, no chargeback, adequate employer response.
That's correct.
I agree with the chairman. Thank you.
A short form dissent, ma'am.
Yes, sir.
Case number 3553932, Commissioner Esparza.
We should modify the appeal tribunal decision. Although the claimant acknowledged the employer's rule against mismanagement company time, the claimant was terminated when she contacted the employer's client during work hours to promote her personal consulting business. Moreover, there was slight delay transpired between the time of the final incident and the discharge. The evidence shows that the delay was caused by an employer's reasonable pre-termination procedures, including but not limited to consulting with senior management and counsel. As such, the claimant's discharge, excuse me, as such, the claimant's discharge was not too remote in time. Since the claimant was aware of the employer's policy, but thereafter violated the policy through engaging in conduct which amounted to mismanagement of company time, claimant's actions were mismanagement of her position of employment and misconduct connected with the work. As such, we should modify the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision should be reversed. The claimant admitted that during a phone conversation with one of the employer's customers during business hours, the conversation turned to topics that involved the claimant's personal consulting business, which was not permitted under the claimant's employment agreement. However, there is no evidence that the claimant brought up these topics to further her own business. Additionally, the employer waited a month after the incident to discharge the claimant. Since the claimant was discharged at the employer's convenience for an incident that was too remote in time from time, the discharge to be considered the cause of the discharge, the complainant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir.
Case number 3559500, Commissioner Trevino.
The AT decision is not supportable. The claimant provided testimony under an oath denying he was drinking or possession of alcohol while at work. A coworker asked the claimant to throw an empty bottle, and throwing out an empty bottle did not violate the employer's policy. The employer's secondhand hearsay testimony as evidence are insufficient to overcome the claimant's sworn denials and insufficient to establish misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response.
We should modify the AT decision. The employer's policy prohibited the possession of consumption of alcohol at the workplace. The claimant was terminated when he was observed drinking on the employer's production floor. Although the claimant denied consuming alcohol, the employer provided firsthand witness statements from coworkers who observed the claimant possess and consume the alcoholic beverage. Since the claimant was aware of the employer's policy, but thereafter violated the policy through consuming alcohol at the workplace, the claimant's actions amounted to misconduct. As such, we should modify the appeal we should modify the appeal tribunal decision, misconduct, no chargeback, sever adequate employer response.
Rehear to obtain firsthand testimony from the employer.
We have not yet obtained a majority vote. The chairman has voted to rehear. The constituent commissioners disagree.
I'll rehear. I'll
Thank
change
you.
mine to rehear.
We'll rehear the case, sir. Thank you. That was the last case pulled for discussion on docket 48. You should have received the UI short form dissent list for docket 48.
I move we accept staff recommendations on the remaining UI cases on docket 48.
I second the motion, except for those cases on which I am dissenting as reflected in the UI short form dissent list for docket 48.
I concur with the chairman's motion, except for the cases on which I'm dissenting is reflected in the UI short form dissent list for docket 48.
Motion passes with the exceptions noted.
Thank you very much.
Thank you. And that brings us to the end of agenda items 1 through 8. We'll stand in a short recess. This is agenda item 9, estimated unemployment trust fund balance.
Good morning, Chairman, Commissioners, Mr. Townsend. For the record, Chris Nelson, Chief Financial Officer. This morning, for informational purposes only, I have the final October 1st trust fund balance, and I'll walk through it quickly with you. We started last October 1st with a balance of 2.13 billion. We received revenue of 2.3 billion on 1.07. We paid out almost 2.3 billion in benefits during that same time period, leaving a ending balance of 2.2 billion for the year. That is above the trust fund floor of 1.34 billion, which alleviates any need for a deficit or obligation tax to bring the trust fund to the floor. It's also below the ceiling, so which is we're right where we want it to be. On the ETIA account, the Employment and Training Investment Assessment, we started the year with 112 million. We collected 135 million, removed our collection cost out of it, and since we were above the floor, we transferred or are going to transfer 28.4 million to cover the skills appropriation since we were above the floor, leaving an estimated balance of 218 million as of October 1st. That's the final balance as of October 1st. We've just got the controller's estimates they've updated their unemployment insurance estimates for this year and next year. I'm looking to bring the first October 1st, 2024 balance here probably in January. And this is just for informational purposes only. So that concludes my comments. I'll be happy to answer any questions.
Any questions or comments?
None here. Thanks, Chris.
No questions.
Are we closer to the floor or closer to the ceiling?
We're actually closer to the ceiling than the floor.
Thank you.
The ceiling would be about 2.6 billion. So we're 400 million below the ceiling, but we're roughly 900 million above the floor.
Got it. Thank you. Other questions? Thank you, Chris.
Next item.
Agenda item 10, modifications for program year 2023 fiscal 2024 allocations distributions for WIOA adult and dislocated workers.
Again, for the record, Chris Nelson, Chief Financial Officer. This morning you have before you the fiscal year 2024, program year 2023 WIOA adult and youth allocation modifications that were previously adopted on May 23rd, 2023 for the contracts that started July 1st, 2023. It's been discovered there was an error in the excess unemployment factor used in the adult and youth allocations that inadvertently provided Alamo workforce area with $147,003 of additional adult funding and $156,127 in additional youth funding. The modification corrects that error and redistributes the funding using the correct data factors by the counties. The net effect of the total allocation is unaffected. This just redistributes the funding the way it should have been done the first time. So that concludes my remarks, and I'd be happy to answer any questions.
Comments or questions?
No questions.
No questions.
Is there a motion?
Chairman, I move we adopt the proposed order modifying the program year of 2023 fiscal year 2024 allocations and distributions for the Workforce Innovation and Opportunity Act Adult and Dislocated Worker Program as recommended today by staff.
Second.
It's been moved and seconded. Motion carries. This agenda item 11, redistribution of program year 2023-2024 adult education and literacy funds.
Good morning, Chairman Daniel, Commissioner Trevino, Commissioner Esparza, Mr. Townsend. For the record, Carrie Ballast, Workforce Development Division. This morning, we have for your consideration a recommendation to redistribute AEL funds. Presently, we have about $1.2 million in funds available for redistribution. Table 1 in your notebook materials outlines the proposed AEL providers who meet criteria outlined in TWC Rule 800.80. and the amounts associated with the redistribution of funds to each eligible entity. Staff are also recommending additional targets to accompany the funds as outlined in Table 2 of your notebook materials. This concludes my remarks, and I'm happy to answer any questions you have.
Comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move we approve the plan for redistribution of program year 2023-2024 adult education and literacy funds as follows. 1, redistribute 1,153,446 of recaptured funds to AEL grant recipients as shown in Table 1 of the discussion paper, and to adjust the program year 2023-2024 performance targets for AEL grantees receiving redistributed funds as distributed in the discussion paper and recommended today by staff.
Second.
Been moved and seconded. The motion carries. This agenda item 12, adult education and literacy career pathways professional development center.
Good morning again. For the record, Carrie Ballast, Workforce Development Division. We have for your consideration a recommendation to increase the budget for the Career Pathway Professional Development Center. Staff are recommending a new request for application with a total budget of $1 million as outlined in your notebook materials. This would be an increase of $250,000 above what was approved by the commission on June 13th, 2023. This adjustment is in preparation for the anticipated outcomes of the upcoming request for applications, which will likely result in more grant awards to manage. Consequently, the AEL team has recognized the necessity to increase funding for technical assistance, which is a required activity outlined in WIOA 223C that details use of state leadership funds. This concludes my remarks. I'm happy to answer any questions you have.
Comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move we approve the increase in the Adult Education and Literacy Career Pathways Professional Development Center funding to 1 million as described in the discussion paper and recommended today by staff.
Second.
Been moved and seconded, motion carries. This is agenda item 13, recertification of CRPs to participate in the purchasing from people with disabilities program.
Yes, good morning, Commissioners, Mr. Townsend. For the record, I'm Kelvin Moore with the VR Division. This morning, we would like to consider possible action for CRPs applying for recertification to participate in the purchasing from people with disabilities program. All 4 CRPs meet the requirements for recertification and are paying minimum wage or higher. Staff recommends the recertification of the following 4 CRPs as listed in the discussion papers. Camino Real, Community Services, Lidle, Texas, Permian Basin, Community Centers, Midland, Texas, Professional Contract Services Incorporated, Austin, Texas, SDR and Associates, Edgewood, Texas. That concludes my comments. Are there any questions?
Any comments or questions?
None here.
No questions.
Is there a motion?
Chairman, I move that we approve the recertification of the following community rehabilitation programs for participation in the purchasing from people with disabilities program as recommended today by staff. Camino Real Community Services, Permian Basin Community Centers, Professional Contract Services Incorporated, and SDR and Associates.
A second.
It's been moved and seconded and the motion carries. It's agenda item 14, board nominations.
Good morning, Chairman Daniel, Commissioner Trevino, Commissioner Esparza, and Mr. Townsend, Courtney Arbor Workforce Division. Today, we have for you board member nominations for Borderplex, Brazos Valley, Capital Area, North Central Texas, North Texas, Northeast Texas, and South Plains boards. Happy to answer any questions.
None here.
No questions.
Is there a motion?
Chairman, I move that we approve the local workforce development board member nominees presented today for the following workforce solutions: Borderplex, Brazos Valley, Capital Area, North Central Texas, North Texas, Northeast Texas, and South Plains.
A second.
It's been moved second, the motion carries. This is agenda item 15, child care local match for board contract years 2023 and 2024.
Good morning, Commissioners. Mr. Townsend. For the record, Sandra Williams, Workforce Development Division. Boards submit annual local match pledge amounts for child care local needs. The supporting documents include 1 board contract year 2024 donation and 30 board contract year 2024 match agreements from 9 boards. Those boards are Central Texas, Dallas, Gulf Coast, Lower Rio, North Central Texas, North Texas, Panhandle, South Plains, and South Texas. Boards have secured 32.39% of the statewide local childcare local match target, with 3 of these 9 boards securing at least 100% of the target. Staff recommends that the commissioners accept childcare pledges for donations, transfers, and certifications for BCY 24 in the amount of $8,002,055. I'm happy to answer any questions.
Any comments or questions?
None here.
No questions.
A motion?
Chairman, I move we approve the acceptance of childcare pledges for donations, transfers, and certifications of expenses for board contract year 2024 in the amount of $8,002,055 as recommended today by staff.
A second.
It's been moved and seconded. The motion carries.
Thank you.
Is there an executive director's report?
Just a brief report, Chairman, Commissioners. For the record, Randy Townsend sitting in for Ed this morning. I just wanted to highlight our highly successful 2023 annual workforce conference. Just to mention, we had almost a little over 1,400 attend in person, and then 260 participated virtually. So it was a lot of hard work, an outstanding job by Lowell, Jennifer, and the entire team to make that a great success. And so I just wanted to mention that this morning to you.
Well, it's definitely worth mentioning. It was a great conference.
Yes.
Thank you. Any other order of business come before the commission?
Chairman, if I may.
Please.
I also want to commend all the work that was put into that conference. I was a great successful conference, and we got a lot of ideas and understanding from about this agency and helps with momentum moving forward. Internally, in our office, in the employer's office, I also want to introduce, we've got new staff, Veronica Rivera. We have coming in. She's our executive assistant. She'll be reaching out and I guess designated party planner for the office, but she comes in from the great county of B County, the pride of B County coming right here to Austin. So we're happy to have her. And we ask that Veronica just push us around as needed and make sure we're on time and on schedule. Thank you, Commissioner. That's it.
Let me, if I could ask a clarifying question. You brought in a party planner from B County, and you somehow think this agency is ready for that move.
B County loves a party.
Yeah. Welcome.
Yeah, I just also wanted to say great job to the staff for that conference. It was my first conference, and y'all made it go seamlessly, but especially to my team, Julia, Elena, Forrest, Rebecca, Ronnie, and Jade, and Sydney. Y'all made it just go flawlessly, and I appreciate it. So just kudos to the whole TWC staff. Thank you.
Yeah, let me triple down on this because lots of moving parts. The meeting has just during my tenure here has always run effectively, but we kind of handed the reins over this year, and so I gotta say we look good once again. I think we definitely made our mark on Houston. I never did. My only significant disappointments with Lowell, the fish never did get put in the lazy river. I checked several times, but he said he caught them all. That's what he just told me. No, it was a great effort, and there's a lot of work that goes into that. I think we all appreciate that. I hope most of the 1,400 people that came appreciate what goes on behind the scenes. Lots of effort on the part of everybody, and these guys know this too. It's pulling together your super session is something that kind of goes on all year, and so to all the offices, my crew particularly, but what you guys were doing, Commissioner Esparza and Commissioner Trevino, great panel that you had there. A lot of work goes into that. I for one appreciate a lot of the information that I pick up there, and it was a good informative meeting. It really was. All right, anything else? We're getting out of here in record time today.
Yeah. Chairman, I move to adjourn.
Second.
It's been moved and seconded to adjourn, and that vote is unanimous. We're adjourned.